We received so many questions that we're going to dive right in and hopefully get through most of them. If we don't get to some of them,
you got to call it.
Please feel free to call us or email us afterwards. All right.
Excuse me, please stand back. If I am in the text chat area, I have to take note of it before you can use your slide as answer. Supposedly. Or maybe not. All right, so start talking. I'll get this
All right.
figured out.
Moving along to the next slide.
So we're going to start with this type of that.
All right, the first question that we received was, is a complimentary textbook that was given to a faculty member or instructor considered a gift? The answer to that question is yes. We have had this question come in before. Obviously, this mainly pertains to the SUNY and CUNY folks. Especially any textbook that you receive invariably is going to be worth $15. And invariably, you're receiving it from an interested source. So it is presumptively impermissible to accept that. Now, we've had the question, well, what do we do with it? We get a lot of these books. The professors get a lot of these books. The cost of sending them all back is prohibitive. So what do we do? The guidance that we've provided on that issue is that the book can be donated to the school, put in the library, but every time this happens, there should be a communication back to the publisher that this is not a gift that the individual can accept and put them in an uncomfortable situation and at odds with Public Officers Law 73. I have no doubt that the practice will continue, but that is the guidance that we've given with respect to that. In answering this question, I looked for advisory opinions. There's really no advisory opinions that touch specifically on textbooks. There's a few on people in state service writing books while they're in state service, but none that specifically addresses this. You note that on CUNY's website, they deal with this issue in some detail, showing that they have a lot more of an understanding of exactly how this plays out in the context of professor performing their job. They perform reviews of these books. Oftentimes they get multiple copies. Apparently at some point they must have had a problem with professors then selling them back to the bookstore. So there's a pretty specific policy, at least on CUNY's website, that addresses how professors should address the issue of complimentary textbooks. Next one. Excellent. The next question I'm not going to handle, but it gives me an opportunity to introduce a new member of our staff, the Director of Training and Education, Megan Henry.
Just as a reminder, for those of you who are participating via WebEx, could you please double check to make sure your microphones are muted? We're still getting a lot of background noise. Thank you. All right. Good morning, everybody online and here. I am, as John said, brand spanking new here, about 2 weeks, but I did do ethics at the comptroller's office for 6 years, so I have a lot of knowledge about it, I think, still safe, right? Okay, so the ethics training. We are curious to know what, if any, additional measures other than their written policies, the ethics online, and the CET agencies are taking to educate their employees regarding the gift rules. Well, this is not one I can really answer. I think I'm going to open it up to people here and maybe online as well. I can tell you some of the things that the comptroller's office did. The ethics unit there had their own website, and they would put, it was a great place to put news regarding ethics stories and had blurbs about each of the major areas, outside activities, gifts, so on and so forth. So having your unit or the ethics officer having a space maybe on your agency's website is a good idea. Also, the comptroller's office did a division, what we called a phase 2 training, and it was for each division listed questions from each of the divisions as to what kind of questions they had regarding gifts or other things, and so we did division-specific live training. So those are some of the extra things that we did there, and that's where I just came from. So I don't know if anyone here wants to talk about extra measures that they took. There is a resounding response here. Do we have any online? Oh, okay.
In DC, especially around this time of the year, right in November, we make sure we send around a general overall gift information, you know, as to what happens when something comes in, somebody gets a fruit platter, somebody gets a whatever, and what you need to do with it. So that at least this time of year, we ought to do another one in the spring. It's like a general kind of thing.
Is it a newsletter or like an email reminder?
It's like an email blast.
Yeah, so our ethics officer from DEC said that they do an email blast to all of their employees, especially around the holidays, regarding questions they've gotten come in and how they've handled the response.
Also, something that, I'm sorry. GOER, I know, is working on a training, an ethics training for all state employees. Obviously, our training that your people are required to take is for threshold filers and for policymakers. I know that GOER has been working on a training that they are going to require all state employees to take. I'm not exactly sure how far along in that process they are in terms of when they intend to put that out. But I know that they have sent the training to us. We've reviewed it. It's excellent, and it should be coming soon. But that's their plan in terms of how to address all state employees. And the next one.
No, well, hang on a second. There is a comment in the second category saying that the Workers' Comp Board has a training program that all employees have to take that covers all ethics issues. So I think that's a good example of, I mean, we do know that there are some agencies that take it upon themselves to do training above and beyond what is required for FCS filers. The Workers' Comp Board is one of those programs. I'm name dropping them because this is a group of people who are by and large ethics officers. So if you are networking and connecting with your peers and trying to get ideas and best practices, that's one area to look at. Okay, next question.
Okay. The next question was, what is the, well, it's in 3 parts. The first part of it is, what is the relationship between a charitable donation and the 2 follow-up questions made it clear to me that what I think this person is asking about is gifts to agencies. However, when I read the first question, it made me think about the charitable event exception and an issue that, well, point of confusion that I myself may have created. So, clear that up. One of the newsletters, I wrote a little part called Dear JCOPE, where the question revolved around an agency employee who wanted to attend a charitable golf outing at Turning Stone at their nicest golf course, where the round of golf probably would have cost about $225 if they had to pay out of pocket for it. And the question was, could they accept that? And I used that hypothetical to make the point that if you read the charitable event exception and the exception for political events, it makes reference to complimentary attendance. Now, the definition of complimentary attendance in the statute, which is up there right now, includes entertainment. We're going to be talking about the widely attended event exception in a little while. And in that section of the statute, they specifically exclude entertainment unless it's inextricably interwoven with the official purpose for which the person is attending. So I wanted to make the point in that there's a distinction between the two, and entertainment would be included under the exception for a charitable event or a political event. However, I left something out. and that is this section of the gift reg, 933.4b. We made it clear when we wrote the regulation in 2014 that for most of the exceptions that we're discussing here today, 5 through 15, even if it falls within the exception, you still have to do the analysis under 74. So, let's go back to that hypo I used in Dear JCOPE. Let's assume that instead of the state employee from the agency I referenced in there, I think it was the Department of Health, that it was a state trooper or someone from the Department of Tax, and they wanted to attend this charitable event. And the charitable event was at Turning Stone. And that at the time they wanted to attend this charitable event, they were involved in active litigation or an enforcement action involving the Oneida Indians. Well, under those circumstances, and this is something I did not include in the newsletter, you might reach a different result as to whether or not the person could attend. It might fall within the exception, but you still might look at 74 and say, under those specific circumstances, this is impermissible because of the appearance it creates. So this is my way of reminding myself and taking shame for not including that, but also reminding all of you that for most of these exceptions, you still have to do the 74 analysis. And the reason I say that and emphasize that is we're going to talk about some of the advisory opinions that reference gifts. There are two big ones, 9416 and 0801, which go on at great length about gifts. And to the extent that the regulation is inconsistent with what's written in those opinions, the regulation applies. And this is one way in which the regulation differs a little bit from 0801 and 9416. So I want to sort of emphasize this in addition to my mea culpa regarding what I wrote in Dear JCOPE regarding the charitable gift exception. Now we're going to get on to what the question really was, which I believe was gifts to agencies. Under what circumstances can an agency accept gifts to the agency? And under what circumstances can an agency actually solicit gifts? If maybe we can go back to the question so it's a little easier to see what we're dealing with. One more. Okay, so see the two follow-up questions. What happens if a vendor wants to make a charitable donation to an agency? The follow-up, how can we make sure there is no conflict of interest besides trying to isolate the agency employees who will be making use of the donation and the agency employees who decide on which vendors to use? Okay. So we can deal with gift agencies, and now I'm going to hand off to Carol Gwynn.
There we go. Okay. All right. So 73 and 74 deal with gifts to state employees, not necessarily to agencies. But we've had many advisory opinions that have dealt with this and deal with the agency's ability to accept them or solicit gifts. Generally, the answer is that they can. They may accept gifts. Go to the next one. These are, well, hold on, before we move on, this slide has lists a bunch of advisory opinions that do deal with this, and if you want to get more detail, you can certainly look at those. Now we can move on to the next one. But basically the answer is yes, agencies generally can accept and solicit gifts. There are a few caveats, of course, to that, and again, we always look at 74 as well, but if the agency is currently investigating the gift giver or in litigation with the gift giver, I would, that seems fairly obvious, but there are advisory opinions that deal with that. That would be where an agency should not accept that gift. Anything along those lines, any true conflict of interest, which I think would be almost apparent, but we do have advisory opinions that specifically say that. But what about a gift giver that just generally has business before the agency, and they're trying to give a gift to the agency? That's where it gets a little bit, that's when we're thinking about the gift analysis a little bit more, and that's when we're really kind of, and it does depend on some factors. So you can go to the next one. Okay. So here's some general rules and factors. If an agency is trying to accept or solicit a gift,
the person who deals with that entity, anyone who has direct contact with contracting, licensing, regulating, investigating, litigating, that person should not be the one accepting or soliciting a gift. Seems reasonable. They should not be conditional. You can't say, you know, why you're giving a gift. Again, that seems fairly reasonable. You always have to consider 74 in this analysis. So again, just, you know, if the gift giver is under investigation or there's litigation involved, the agency shouldn't accept. If it's something where the agency might do business with an entity, you're going to look at some of these factors as well and do some analysis. And of course, you can always call us. I think actually I can stay here. So one of the, we have one advisory opinion, which was 99-4, where we actually said no, this was not allowed. And this is a solicitation example. And the end result was soliciting on behalf of a private entity. So this is not, you're not soliciting a gift to the agency. You're actually, in this case, which involved the New York State Emergency Management Office, they were trying to almost partner with a non-for-profit. And the issue there was whether an agency could assist one of the non-for-profits it works with raising funds for that nonprofit. In this case, we said, again, it's 99-04, we said that was not allowed. Part of the analysis was the not-for-profit and the solicitation was really for a private entity. It wasn't for a public entity. And so this is an example of where we said it was not okay. We would also say it was not okay in other advisory opinions where, you know, like I said, the litigation, the investigation, that type of thing. Also, if you're soliciting on behalf of someone else, I think that's even, you have to even do more of an analysis. And this is an example, 99-04, of where that was not allowed. So that's one way of looking at it. And again, the ultimate result was you're soliciting more on behalf of a private entity. That's generally impermissible. Okay. Now we're going to hand it back to Megan for widely attended events exception.
Widely attended events. So many questions I know came in on this topic alone, and that was one of the issues I dealt with a lot when I was in the Comptroller's office. So we'll launch into this one. One of the 4 conditions to qualify for the widely attended event exclusion is that the event is related to one's official duties or responsibilities. How broadly should this be interpreted? And then there's a follow-up. Does the opportunity to network at the event with people in your industry satisfy the related to official duties or responsibilities conditions? There's another question, but we'll deal with this first one. So does the opportunity to network at the event with people in your industry satisfy the related to official duties or responsibilities condition? I'm just going to briefly read part of the reg. So it says, a covered person's duties or responsibilities shall include but not be limited to. And then you have those first 2 factors. So first one, for elected covered persons, only or their staff attending, only attending an event or a meeting at which more than one half of the attendees or people, persons invited in good faith to attend are residents of the county, district, or jurisdiction from which the elected covered person was elected. Or, I know it's not fun. I'm just reading it, so it's out there. For all covered persons attending an event or a meeting at which a speaker or attendee addresses an issue of public interest or concern as a significant activity at such event or meeting. So when you go back to that first part, a covered person's duties or responsibilities shall include. So it has to be, if you're not an elected covered person, there has to be usually a speaker or attendee addressing an issue of public interest or concern. You're networking and there's no speaker, you're just walking around and saying hello to all your friends there, having a cocktail or whatever. I don't think networking is generally going to be considered related to official duties or responsibilities. I never came to that conclusion when as a former ethics officer. If anyone has here or online has ever said networking alone would be sufficient, I would love to know, because we have never come to that conclusion. So that second part, if the event is sponsored by an agency or person or is in honor of someone with whom the invitee had a prior working relationship, does that change the analysis in determining whether attendance at the event is appropriate. So, the part we're looking at here, with whom the invitee had a prior working relationship. When we were talking about these questions, what we were thinking is, so if the person is an interested source currently, you try fitting it into that widely attended event exception. But then you always have to look at 74 next. Are there any matters pending that would disqualify the exception? Then if the event does not fit an exception, here we are again, then it's presumptively impermissible if it's coming from that interested source, if you can't fit it into an exception. If the person is not a disqualified source, so it said the invitee had a prior working relationship, you might not have anything that makes them an interested or disqualified source right now. And it fits in that exception. What I think we're trying to stress today is you still have to look at 74, no matter what. So is there any reason that it could be inferred that this widely invitation is trying to influence them or reward them? That's where we land on that. Does anyone else here have comments? Comments here? We have a question in the audience or a comment?
I have a question. It's not from an interested source, but it is a networking event. It's a cocktail reception or whatever. And it's not somebody looking to do business with the agency, it's just for the network. Is that permissible?
Okay, so the question was, you have a networking invitation and it's not from an interested source. So we didn't talk about this, but it's not from an interested source. We would say, what? I don't know.
You still have to have a nexus to their official duties.
Right.
How does it advance? How does this advance? It has to be related to their official duties.
Yeah, if the networking is, going to be other people in the industry that are going to be there, and they see this as, important to make sure that they're also there, but it's not being sponsored by somebody that we have a contract with or do business with.
I think the danger there, when I read this, I thought of the slippery slope, is that if we say that networking per se is good enough to constitute being related to their official duties, we've now just created an exception that swallows that requirement. I think, and we try never to say never and never say always, is there a scenario where someone in the agency, the nature of their responsibilities is such, for example, the statewide elected officials, we try to give the agency broad discretion in determining what fits within any particular individual in that agency's official duties and responsibilities. There's a straight face test that still has to pass. We don't sort of just surrender on that. There may be times where we say, it's not that elastic. But use the example of the statewide elected official, whose obligation is not only to promote their agency, but also the interests of the state. They're sort of the public face of the state. Someone like that, depending on how high up they are in the agency, might have an argument that they could make, a reasonable argument that they could make, that this is indeed related to their official duties. So I think the higher up in the organization, the more chance you might have of making a good argument that this networking and sort of being there as the public face of the agency constitutes related to their official duties. I think that's why we also include that part about a ceremonial function, because we understand that they sort of have to be the public face of the agency. But further on down the chain, I think that stretches it to the breaking point. That requirement has to mean something, as much deference as we may show. It has to be related.
And I haven't been here long enough to know what our answer should have been. So that's why I said, John, come on up. And
We have a question from our remote audience. What about attendance at a luncheon to celebrate the opening of a facility that was a partnership between the state agency and a private not-for-profit? Opening luncheon celebration to this facility.
Again, I think I would come back to who is it that's attending. Now, if this is the person that is going to be in charge of that state facility or someone higher up in the organization, the agency, then you can make that argument. But it still has to be made with respect to the individual on the merits as to who that individual is and how it's specifically, you have to articulate it. You have to be able to put down on paper, this is why I think this is related to that person's official responsibility. And simply saying networking and leaving it at that, I don't think covers it. It makes it a little too simple and creates the danger for that slippery slope.
And are people making remarks? Do they have a program? I would say.
It doesn't matter if you pay for it on your own, if it was a luncheon.
If you pay for it, it's never a gift.
So you could go.
Yeah. That's an excellent point. I'm glad you asked that question. Before, when I talked about how 74 still comes into play here, it only comes into play for exceptions 5 through 15. Well, there's still 1 through 5 in those list of exclusions. One of those is if you pay for it. You pay for it, it's never a gift. You don't have to worry about 74. It's always fine. No one can infer ever that that's an attempt to reward or influence you for how you conducted your state
So
business.
even at a networking level, when it's strictly just that $25 fee to go to this event, and you pay the $25,
I think you're fine. It's not a gift.
So the question was, so even at a networking event, if I paid the admission fee, is that okay? Yes. Yes, that's okay. All right. No other questions?
Okay, this is a slide that I put up just because I want to make the point that we get questions about what does it mean to be widely attended. So I took this language out of 0801, which is really just directly quoting Advisory Opinion 9416. What does it mean to be widely attended? I like this definition, which is why it's up there. It's open to members from throughout a given industry or profession, or if those in attendance represent a range of persons interested in a given matter. Now, the next hypothetical that we have that we were asked is this. State employee, if a state entity's employees are involved in external industry-related working groups, both dues-paying and non-dues paying, what activities may they participate?
Wow, that was weird.
You good?
I'm doing some house music later.
Our equipment is possessed.
Okay, that was something very weird and unusual, and I have no explanation for it, and I didn't fix it. So if it happens again, we'll just dance. Okay.
So the question is, if a state entity's employees are involved in external industry-related working groups, both dues-paying and non-dues paying, what activities may they participate in without running afoul of the gift rules? Well, when I read this, I was struck by all of the different things could be included in external industry-related working groups. That is a very, very broad term. So if someone came to me with that question, I would have a lot of questions to come right back at them with. I would want to know exactly what is the nature of this external industry-related working group. And depending upon what they told me, that would really have an effect on what my answer would be. For example, the Attorney General. There is the National Association of Attorneys General. Now, everybody in that organization is the state officer or employee. We're all Attorney Generals. I'm hard-pressed to think of that as an interested source. You could almost make an argument it's somewhat a governmental entity. I'm not going to be as concerned. If it's an employee organization, this is union activity they're referring to, well, we all know that in 73, as well as in the regulations, we carve out a special exception for those types of organizations. They're essentially excluded from this analysis. I think that what the person is asking about is examples where you have people in agencies that have a certain expertise or a certain profession. If you're talking about an engineer in the Department of Transportation, and they're a member of a professional organization of engineers. And now that entity is having a conference. How do you analyze it? Well, you have to look at what that, you have to basically go through the same analysis that we go through for the widely attended event exception. Let's talk about the conference. Who is going to be at it? And I'm just using that as an example because this is somewhat of a vague question. Now they're attending a conference for that engineering association where they're going to be discussing issues related to road building. They work for the Department of Transportation. Well, I imagine that the people in that group are other state employees from other states who are engineers working for the state, but also engineers working for private contractors. So there's going to be a mix. And even if the state, the group itself is at a lobbying group, they lobby in the state of New York, which would make them a per se interested source. What types of groups are funding the activities of this association? Is this mainly funded by the private contractors and the engineers that are going to be showing up here? Generally speaking, I think that it's okay to attend these events because the official duties element of it being related to the official duties is so strong. That component of it is so strong. That it's clearly related to their official duties to stay at the top of their field, to have the input of people both in the private sector and in the public sector in terms of how these jobs get put together. But I think you have a very strong argument that it's related to their official duties. However, I still want to know, well, where is this event taking place? They laugh at me when I use this word. How swanky is it? Because we still have that 74 analysis in the end. What else is going on at the event? Is this a 3-day event and the last day or the first day is just a golf outing where everybody's going to be networking? This is the way you have to parse that because certain aspects, their own complimentary attendance, let's remember what the definition is. Attendance, food and beverage, if everybody at the event is receiving the same food and beverage. No special perks, no entertainment. You have to look at all those things and really ask a lot of questions of the person that's asking for permission to go to this particular event to determine whether or not it fits within the widely attended event exception. If the entertainment is out, where they're staying and how nice it is actually matters. And how are they footing the bill for the rest of it? Because again, it can only be attendance, complimentary food and drink when it's offered to everybody else. Second question is, well, fee waived at the conference attendance. That's not a problem. That's exactly what complimentary attendance is. Can the state entity sponsor a monthly meeting on site or at a centralized location, including food and beverage for all attendees? Again, this comes back to the analysis of in what way is it related to the official duties. Does this advance the mission of the agency? If the answer is yes, the agency comes and tells me that, I'm going to show great deference to that determination. Obviously, the third question, organized golf or other recreational outings at the conferences if included in the registration fee. I don't care if it's included in the registration fee. They can't be part of it. Unless they can make the argument that the entertainment is inextricably interwoven with the entertainment. And honestly, when people try to make that argument to me, I'm inherently suspicious. We do get calls sometimes, and I have trouble when I'm talking to the person on the phone because I don't know if this is a person who really wants to understand what the law requires so they don't run afoul of it, or if this is someone who's trying to dance between the raindrops and they want to know, how do I orchestrate this event to cram it into the widely attended event exception? When people make an argument to me that the entertainment is inextricably interwoven, my mind immediately is suspicious that they're trying to orchestrate the event to fold the entertainment in and make that part of it. So I'd be honest with you, I'm inherently suspicious when people try to make that argument that the entertainment is inextricably interwoven. I imagine the agencies are too, and this is a good point to make, that everything we're talking about here today, I make this in every presentation, I make this point. JCOPE is concerned with the baseline for applying Public Officers Law 73 and 74, the circumstances under which we might bring an action against somebody. Agencies have and do go well above and beyond what we set as the baseline because they have a greater interest in protecting the image and the reputation of the agency. So there are many instances where we might say, yeah, the optics aren't good, but technically I don't think that's a 74 violation. Well, the optics may be enough for the agency to be completely within its rights to say no. JCOPE might have said yes, we're saying no. So I know that is troubling to some people sometimes because you come to us looking for cover, because You don't want to be the one that says no. We're happy to be the fall guy when we can and say no. So you have somebody to blame, but understand there's a sort of a tension there between our mission and your role as the ethics officer for the agency. Sort of that whole thing about where you stand depends on where you sit. And we sit in different roles. I wanted to make that point. Next one. Okay. All right. All right, this is what we put it up there, and then when we were reviewing it, we realized we kind of covered this graph. Unless anybody has any more questions that come to mind as a result of reading this, we're going to go on to the next one. We'll give everybody a second online to see if they have a follow-up or they want to dive a little deeper into widely attended event. Actually, we have a few more questions on widely attended event. We all good moving on off this one? All right. This one is new.
Okay, so I think we received this question, and it was about an administrative law judge, but it can kind of apply to any agency employee. The question basically is, can an agency employee, let's say an ALJ, accept an invitation, complimentary attendance, food and beverage included, to speak at an event hosted by an interested source? Let's say it's a claimant's law firm that's hosting some event. Can they go? Can they eat lunch there? Even though it's free for some people, because they're dues paying members, does that make any difference? The first thing I look at when I think of this is, does the interested source have a matter before the ALJ or the agency employee or the agency right now? If they do, then we would say the agency employee or the ALJ should not go. Okay, that seems reasonable. But if let's say the interested source had a claim a while back, or had some kind of business a while back, or maybe might in the future, then I would lean towards it might be permissible. We wouldn't say no, but we'd have to go through the widely attended event analysis. So we would look at, for example, who's attending. That would be the first thing. Who's attending this event? If it's just members of the law firm, that probably would not meet the qualification of at least 25 others. Okay, but let's say instead of just the law firm, let's say everyone that has business before the agency, or other people that have business before the agency, or for an ALJ, for example, there's a bunch of people there who also litigate or have claims before the ALJ. So it's not just the law firm. Then it might be okay. Then you go through the rest of the analysis. But that would be the first piece. So, as we've all been explaining, and as John just went through, we look at the factors of the widely attended event in this case. Is this speech or this attendance related to the ALJs or the agency employees' duties and responsibilities? We look at that again. What's the purpose of the employee's attendance? Is there an issue of public concern being addressed for some reason there? Again, the food and beverage has to be given to everyone, not just the ALJ or the agency employee. And then we would be looking certainly at 74 and what's the interest of before the ALJ, or what interest does the sponsor have? And this, again, I feel like we're repeating a little bit, but these are the things we have to go through. And again, as John says, when we do joke with him, he talks about if it's blanky or not. So this is a fabulous thing, and it's something we would all in this room love to go to. We would look at that a little more carefully. I mean, a conference here, and we have some bagels over there, that's not something that would really grab our attention as long as the other factors were met. But if it's a really, really fantastic event, then you're looking at 74, and is this person getting unwarranted privileges because of their position, for example? So those are the things we would look at. But again, first thing is if there's an interested source and they have something right before the ALJ or the agency, don't go. If that's not the case, maybe it was previously they had something, maybe they will in the future, then you go through the entire analysis. And the first thing I would look at is, again, is there more than 25 people attending outside of the law firm or outside of, and then if you get past that, then you go through the other factors, and we would look at that. And we would generally discuss these things, and we usually have a group discussion on these things. We'll go through it. I don't know if there's any more questions on that. Okay, next one.
Right, I'm back. This one has many layers to it. How do you analyze a situation in which an agency administrative law judge has a friend from law school that is an attorney for a firm that appears before the agency. So the first part of this, what if the friend appears before the law judge? We were discussing this morning again. At minimum, there should be disclosure, and we thought recusal of the judge from hearing that if it was a friend from law school, a personal relationship. Can the agency law judge accept a wedding gift from the friend who appears or whose firm appears before the judge? Hey, can you go to the next slide? So in this case, we would go into the exception of, is it a gift from a friend or a family member? Does it fit into that analysis? And we'll briefly go through those factors. Gift from a family member or person with a personal relationship with a covered person when it is reasonable to infer that the gift was primarily motivated by the family or personal relationship. And then you go into those factors in determining whether the gift was primarily motivated by that relationship. We go on to the next. We look at the history and the nature of the relationship between the individual offering the gift and the recipient, including whether items have previously been exchanged. So we would need to know more information. Their law school friends, have they given gifts back and forth before? Are they always going to each other's house? Are they going to dinners together as friends? Whether the item was purchased by the individual offering the gift. So if the firm is paying for it, if it's being written off as business expense, that's not going to qualify. Whether the individual offering the gift at the time gave similar items to other covered persons. And like I said, if they're seeking to deduct it as a business expense, that is not going to qualify. Okay, can we go now back to the hypo? There were a couple more questions here.
Back one more?
Mm-hmm. All right. Can the agency law judge attend the judge's friend's retirement party hosted by the firm? And now the part that we need to look at here is that the invitation is coming from the firm, and we're assuming that the firm is disqualified, I keep saying disqualified, interested source. And so if the invitation is coming from the firm, we thought that, especially if there was a matter going on, you're looking at that 74, even though it might fit in that exception of it's from a friend, if the firm is giving the gift, you would probably not be able to take it. However, they should be able to go to that friend's retirement party, so they should pay for their own meal in that instance. And in the last part of the question, can the agency law judge go to the friend's house for a barbecue knowing that the friend has also invited members of the law firm that appear before that law judge? Again, we go into that friend exception. He could probably go after applying all the factors if that friend typically invited him to such events before. Is it something that's coming up all of a sudden? Then that might not fit into that exception. And that's where we landed on that. Are there any questions regarding this one? Okay. Right. Oh, I might be the next one. Let's see.
Sure. I just want to say something about, I think this is the interest. The example of the administrative law judge is certainly another instance where the agency may want to have a stricter policy than necessarily JCOPE would. We're bound by our advisories in offering up an opinion. However, when I think of an administrative law judge, this is someone whose impartiality has to be above and beyond reproach, beyond question. Not just because of the public officer's law, the Code of Professional Responsibility, this person's probably an attorney. So I can see how the agency would be incredibly sensitive in terms of what it allows an administrative law judge to do. And I'm trying to walk a mile in the shoes of the ethics officer, and I'm reading these questions, and I'm imagining that the ethics officer has administrative law judges coming at them all the time wanting to do things, and they're having to say no all the time. And that it's a struggle, and it's difficult, and maybe a little uncomfortable. What that person should be made to understand when they come to you, when they're making the argument that they should be allowed to go to this event or accept this wedding gift or whatever it is, they want to fall within that exception that exists for friends, law long-standing friends and personal relationships and family. At the same moment they're making that argument to accept that gift or go to that event, they're also making the argument under 74 as to why they have to recuse if that person or that person's firm is ever before them. So on the one hand, they may be arguing that they should be able to go, but on the other hand, they're arguing against themselves. And this is a situation where we're going to show deference to the agency. We're going to set a baseline. It's very easy for me to sit here and say, well, they're going to have to recuse if, in fact, if there is this intensely close relationship. But I don't know what the practical realities are for the agency in terms of how many administrative law judges they have, what the workload is, and what it means. I don't know what the size of that firm is and how much business they do in front of the Workers' Compensation Board. So the agency may say, we're erring on the side of you not being able to go to these things because, frankly, we need you to wall yourself off from that relationship because we can't afford to have you recuse in terms of how the agency just conducts its business. So it's just an example of where there's some space between what we may set as the floor and what the agency might determine in terms of how it deals with its administrative law judges, because I know that many agencies have them, and it's a very sensitive issue because of the incredible power that they have.
Follow-up question, yeah?
So if there's a baseline and we make a more difficult, stringent standard on that, is there an appeal for an employee?
No.
Okay.
Okay, the question is, if JCOPE sets the baseline and an agency sets the standard higher, is there any appeal function for an employee at that agency?
No, and this comes up all the time in outside activities where the employee will try to split the parents. They try to come to us first and get the yes, and then come back to the ethics officer and the agency and bludgeon them with our letters saying, JCOPE said it was okay. We will always have your back when you say no and defend your right to say no and set a higher standard, regardless of what the issue is under the public officers law.
Okay, so we're still on the same slide. I think we got a lot of questions dealing with ALJs, but it applies to everyone. What if you used to, a law judge used to work for this firm and now handles administrative cases? Can they, they obviously have colleagues and pre-existing friendships with that firm. Can that law judge have dinner with the attorneys from the firm? And this, this could be one of those situations where what we would suggest is, yeah, sure, go out with your friends. I'll pay for your dinner. And that's what if the law judge is married to someone at that firm or any firm that appears before the judge? Okay, the first thing that person should not be hearing those cases. They should recuse. That's the answer. It's not about whether you can accept the gift. The first thing is you should be recusing. You should not be hearing cases or you should not be handling matters because, and one of the things actually, the question says member of a law firm. We would actually ask, is that person a partner in the law firm? And I think that makes a difference. If you're a partner in a law firm, you get receipts, the profits come to you. So you can't say, well, I'm going to hear the case from their, that so-and-so's partner, and it could be a 100-person law firm, and that maybe you can say your wife or your husband doesn't even know that person, never deals with that person. It really doesn't matter. If you're a partner in a law firm, you're going to receive profits from that law firm. Anything to the benefit or not to the benefit of that law firm and the law firm's clients that you're deciding makes a difference and can affect the pocketbook of the bonus check at the end of the year. So we were assuming by this question that the person was a partner. Now, when you get involved with attending like a birthday party for children or that type of thing, I think, like I said, you should be recusing. You should not be hearing cases anyway. Once that's done, there's really you're walled off from that firm. You're walled off from your wife or husband's firm. And that should be the answer. Then, of course, you can go to the birthday party of your colleague's 6-year-old. And, we also hear about holiday parties also. Again, you can go to your spouse's holiday party, but you should not be hearing cases of your firm. And it's circular reasoning, but it's the same answer. Recuse, and we're assuming by this question the person was a partner. And, that's just a 74 problem at this financial interest in you can't decide you can't decide that case. You could go to the birthday party, you can't go to the holiday party, but should be recusing to begin with. That's that.
We like to move around a lot here at JCOPE. We love the fire drill. All right, in district, over time, the same practitioner appears before the same workers' compensation law judge. And that judge's staff. They become friends, develop a relationship. Practitioner has food delivered to the board staff around the holidays. The practitioner provides promotional items from the interested source to the staff. Can the agency accept these? Well, here's the rule on food as far as the guidance that we've given. And this happens all the time, I imagine. If the nature of the gift is perishable, the fruit basket, the tray of food, whatever it is, what we have said is it's not practical to return it. However, so that there is no inference that could be drawn that this is a reward that might influence someone, what should be done with it is it should be made available to everyone. Now, if at all possible, everyone should include the public. But at the very least, it should be everybody in the agency, so that if anything, you can make the argument this was a gift to the agency. I would also say that in any instance where that happens, and I know this is where you have to be diplomatic, you have to gently say to that individual or entity that they, as much as you may appreciate it, they put you in a very uncomfortable position when they do this because they put you at odds with the public officers law. Blame it on the jerks at JCOPE if you want to get out of an uncomfortable moment, but I imagine this happens with some frequency. This used to happen, I used to be at the state police, and this used to happen at the state police all the time, where people would anonymously come by because they were happy about someone who helped them a trooper that helped them on the side of the road, and they would leave gifts anonymously, the $100 gift cards at local restaurants. And what do you do with it? Well, a lot of agencies have this problem, and many of them have policies in terms of how that event has to be documented and what has to be done with that gift. State police, they would literally do a report as to having received it. So it was documented that they received it, and then it would have to be donated anonymously to a charity. They couldn't keep the gift. They couldn't spread it around amongst the agency. They had to try to return it if they could, but if it was done anonymously and there was no way to figure out who gave you the gift, and that would happen, then they have to dispose of the gift in a way that there can be no inference drawn that anyone in the state police received the benefit, and that's documented so they can prove what was done with it. The second question, can the practitioner provide promotional items to the staff? Can the agency accept these? Well, I want to know what the promotional items are. We have an exception for promotional items. What we contemplate by promotional items is the sort of swag you get at a conference, the pens, the cozies, things like that, the pads, stuff of nominal value with pretty much no resale value. So I'd want to be sure about exactly what that promotional item was, but if it's something that's being offered to everybody in the agency, there is an exception created for that. Now, again, that's one of those exceptions where you have to think about 74. And what is another practitioner going to think if they see a bunch of pens with the name of that petitioner's law firm and everybody at the agency using the pen with that attorney's name written on it? I could see as an agency saying, please push that back across the table. We can't do that. But we do have this exception. And as far as JCOPE is concerned, in 73 and 74, if it has no resale value, it's swag, as it were. Public officers law and then the regulation has this exception that exists. I might encourage an agency to push back against that under the circumstances, depending upon the circumstances, but that's the rule. Switch.
Okay, we have one that intertwines a widely attended event with awards/ceremonial items. If an interested source wants the commissioner to attend their annual meeting to be recognized for their public service in relation to that company, can the commissioner attend the meeting? Can they accept a plaque in recognition of their service? Can the commissioner eat the lunch or the dinner offered at the meeting? to all attendees, or should the commissioner not partake in the meal based on POL 74? So here we go again. We would have to go through that whole widely attended event analysis again. Are we satisfied that there are 25 or more persons outside that agency being invited? How is it related to that attendee's duties or responsibilities? Purpose of the event. It's just an awards dinner and there's no program or speaker addressing an issue of public concern. It might not fit that widely attended event exception. Is there some sort of entertainment plan during the event? Is the food and beverage available to all the folks? So go through all that analysis. Now, can the commissioner accept a plaque in recognition of their service? We go to that exception, and it might fall into the exception for awards and plaques. It must be publicly presented or intended to be publicly presented and in recognition of their service. Related to that covered person's official duties and responsibilities, we have to ask ourselves, are we making sure that they're giving an award related to that person's duties and responsibilities? Has that kind of item been given customarily bestowed upon people at similar ceremonies? Is this the first time this has ever happened before? They're doing something special for that commissioner. It might not fit into that exception. Also, we want to make sure that it is a plaque or ceremonial item that is typically bestowed. So, is it just a plaque? Is it something engraved? Maybe a bowl engraved, but are we trying to give them something that maybe has resale value? We were talking about this before. I guess that's happened before, where it was something that was really nice and could have been worth thousands of dollars, and so that might not fall into that exception as well. Any questions on that?
On that last one, again, from my days at the state police, an example of an award where you sort of have to ask what's the award. They give an award every year to the Trooper of the Year. And the Trooper gets a lovely plaque. They also get a very nice handgun. Now, the handgun is presented by the Troopers Union. And you can make an argument both ways there. The Troopers Union is a registered lobbyist, so by statute, interested source. However, Troopers Union giving a gift is kind of like when everybody at the holiday time of year takes a collection to give a gift to staff. And that's not something we've ever treaded. That's territory we've never gone into in terms of saying that that's impermissible. So that one really sort of toes the line in terms of whether or not that's a permissible gift, whether that would fit within the exception. So I only mention it to make the point that when someone just sort of says it's an award, press a little further, ask questions, really sort of pull out the details, because that's usually where the devil is, and the smallest of facts can make a difference in terms of the conclusion that you reach. All right, on to discounts for goods and services. If an agency has multiple facilities across the state, can employees accept discounts from local businesses in a particular region that may not be offered to employees located in a different region of the state? Please provide general guidance in the area of acceptable discounts as well. I'll start with just going right to the statute. Here's what the statute says. Goods and services or discounts for goods and services must be offered to the general public or a segment of the general public, defined on a basis other than status as a covered person, and offered on the same terms and conditions as the goods and services offered to the general public or a segment thereof. If I just read that by itself, I would think discounts for state employees and just state employees is prohibited. However, go right to the next section, notwithstanding section 9, the section above, discounts made available to all covered persons fall within this exclusion. So how do you parse that? What's the difference there? They seem inconsistent with each other. There's a couple of advisories that deal with this. Trying to remember which ones they are. I can tell you. So you can consult them. 0501 is one of the advisory opinions. The other one is 0804. And here's how they parse that. A segment of the population, obviously by virtue of that second part of the regulation, can be all state employees. And the rationale is that someone would have to be really unreasonable to infer that someone would give a benefit to 250,000 people just to influence one person. So that no reasonable inference can be drawn under those circumstances that this is an attempt to reward or an attempt to influence. So everybody thinks of the example of the Verizon discount. I think the first one I mentioned, the 05 decision, deals with hotel discounts and the phone discount. These are discounts that are offered to all state employees, open and available to all state employees. Now, those are national companies that provide these types of benefits, so there is no issue about, well, what if they're only offered locally? So I'd want to know, in the instance of a local business, well, what is the nature of the discount being offered of that local, by that local business? If you ask the owner of that business, what would they say the discount is they're offering? If their answer is, this is the discount I make available to all state employees. Now, the truth of the matter, the only people that are even close in proximity that work for the state are the people that work at the correctional facility down the road. But if someone walked in from Albany who was with the Department of Health and they showed me their state ID, they'd get that discount too. I don't have a problem with it. If their answer was, well, this is just something nice I do for the doc's employees, that is a subsegment that is not included in that definition in the second subsection. If that covered person is just a member of a particular agency, that this is a discount for one agency to the exclusion of all others, it doesn't fit within this exclusion. Another example, let's say it's a law enforcement discount. So it's not all state employees, but there are several agencies that fit within the definition of law enforcement, state, local, and federal. I think that is a subsegment of the population where it would be permissible to accept a discount. So the three things that they've specifically weighed in on in advisory opinions are the phone discount, the Verizon discount, travel rewards. People that are traveling on state business, they accrue reward points as part of their travel. Can they use that for personal use? Yes, they can, according to our advisory opinion. The other one that we get a lot of questions on is the state rate at hotels. In fact, I think we have a couple of questions coming in a little bit that deal specifically with the issue of the state rate. And the hypothetical, well, what if I have state business on Friday in New York City, and I get the state rate for Thursday night, but I want to stay the weekend? Can I get the state rate? What if I don't have any state business, but I want to go to New York City for the weekend, and I want to know, can I take the state rate if they'll give it to me? Well, the answer is a qualified yes. What the opinion on that says, as long as you don't engage in any sort of subterfuge to try to trick the hotel into thinking you're on state business, and they're willing to give you the state rate, so it's a pretty simple conversation to imagine. You go in, you show them your state ID, you say, hey, I'm not here on state business, but I want to know, will you give me the state rate anyway? There are plenty of hotels, surprisingly, that will give you the state rate. That's okay under our advisory opinions. There's no problem with that under our advisory opinions. This is another example where there might be a little difference between what an agency tells you you can and can't do and what we set as the baseline. But those are discounts that our advisory opinions that we're bound by say that you can accept, and the rationale again is that this would be a hell of a way to try to influence one person to give a benefit to tens of thousands or even thousands. Any questions? Oh, by the way, if you get the state rate, don't fill out the tax exempt form if it's personal business, if it's personal matter. That's a dead giveaway. You might try to trick them. All right, and this is just the regulation that lays out how you come to that conclusion. And there's the hypo that I spoke about before about going to the city on business and staying the weekend. Me too. All right, gifts between state employees. I kind of spoke a little bit about this before. This came up recently at an ethics seminar that I was doing for the Attorney General's office. It's always a dangerous situation when you got a room full of lawyers. One of the examples in our ethics seminar is an enforcement action that we had against the fellow who worked at SUNY Cortland. He worked in the athletic equipment room. And this is a guy literally who cleans the bathrooms, washed the uniforms, knocked the mud out of the cleats. Now, any Jets fans out there, you know that's where the Jets have their mini camp in the summer. And over the course of 5 years, the players, as they do throughout their day, every day of their lives, they're handing out the swag. They're handing out the jerseys. They're handing out the caps, maybe a couple of tickets here. They're tipping people. Well, over the course of 5 years, he got about $4,700 in tickets, money, and Jets apparel. We brought an enforcement action against him. Not because anybody could infer that there was an attempt to influence him, but because he was getting a reward from a member of the public for doing his state job. And the most hyper-technical reading of 73.5 says you can't do that. Well, as soon as I went through that example, man, they were hopping mad. Nobody likes that example because it seems unfair. And they came right at me. Are you telling me that we can't get a collection around Christmas time for the support staff? I mean, technically, we're rewarding them for doing their state job. Is that what you're telling me? And they were on me. Here's what I think the distinction is. I think that's okay. You will not find an advisory opinion or enforcement action where we have treaded into that territory. We did something about this in our newsletter, because I do still think you have to be careful. The reason we think that's different is that's within the agency. This is not something coming from a member of the public. But a member of the public, even if they're not trying to influence you, when they give you a tip, something extra for doing your job that you already get paid to do, the rest of the public is left to wonder whether or not that was a reward for some particular action, whether or not that person is getting special treatment because they're giving something extra. That's the distinction. If this is something that's occurring within the agency, where everyone is gathered together trying to show appreciation to someone for the hard work that they've done for them, and all the abuse maybe they heaped on them during the year and they want to say thank you, that does not implicate anything in the public officers law in terms of a reasonable basis to believe that that state employee is doing their job differently vis-a-vis the public as a result of receiving whatever that gift is. So whether it's a birthday or it's the holidays or it's Secretary Appreciation Day, that is not an area where JCOPE treads. You may take up a collection, but as I said, you still have to be careful because in many of these, in all of these agencies, you have a structure and you have superiors, supervisors. And I imagine this exists in any organization, but 74 does technically come into play when you're talking about a state employee. So if it's the bureau chief leaning on the subordinates to kick in for a gift for one of the secretaries or all the secretaries, arguably they're using their authority to extract something from these people. They're exercising undue influence on those people. They're abusing their authority. Potential 74 problem. Do I think we would ever go there? No. But again, the example of that athletic equipment person tells us that we are not above at times. Remember, it's 14 commissioners who decide whether or not there's a violation of the Public Officers Law 74. We are not above hyper-technical readings of Public Officers Law 74. So while that issue may be litigated in the context of hostile work environment and retaliation, and you may be dealing with GOER, there's an angle there with Public Officers Law 74. So that's a long-winded way of saying we don't tread on in the area of gifts and between employees, but there are reasons to be careful in how you go about doing it that may implicate Public Officers Law 74. So I think the advice that we give in the newsletter is that superiors shouldn't be hitting up subordinates to contribute, whether it's buying cookies for their child's bake sale or cookies, Girl Scout cookie sale, or collecting money to give a gift to somebody, they shouldn't be doing it. It should be made clear that no one is obligated to contribute. And whatever gift is given should be done so anonymously so that there's no sort of keeping score about who cares and who doesn't. No one's left to wonder about retaliation because they decided not to contribute. Any questions on that? Okay, this is just another twist on it. Can a supervisor accept a holiday gift, a value in excess of $15 from a subordinate? I would think no. For all the reasons that I just discussed. Giving the impression that you can be influenced in the way that you perform your state responsibilities. Think of state responsibility. We usually think about this in the context of how that person exercises their authority vis-a-vis the public. Why can't it be how they exercise their authority vis-a-vis their subordinates in terms of who gets promotion, who gets overtime, who gets positive review? If it's a collective group, if the group all gets together and gives you a gift, I think that's a different story. But if one of them is giving you something extra nice, everybody else in the office is left to wonder and question every decision that you make thereafter and what motivates it. And then we have the final example, the final question about the tray of cannolis. This goes back to what we talked about in terms of perishable gifts and putting them out in the public if possible, and certainly sharing with the agency, everyone in the agency, so that at least you've treated it as a gift to the agency as opposed to an individual and beg the sender not to do it again. That it? That's it. You guys got any questions? Sure.
I think I know the answer, but with regards to that last one about the subordinate giving a gift to the supervisor, if it's a secret Santa and there's like a $20 limit, you don't really know who they
It's
give it
anonymous.
from, that's fine.
The question was related to secret Santas. If you have a gift limit of $20, because the gift is anonymous, is that okay? So the answer would be yes.
Yes, I don't think that that creates a problem. And again, these are more issues that I would think would be put at the feet of GOER rather than JCOPE. I don't expect anything like this ending up on our radar. But technically, yeah, there are Public Office Law 74 implications there because those principles are so broad and so subjective. You cannot give the impression that someone has your favor in how you exercise your responsibility. We good?
Any last questions to our remote participants? Type them in the text chat area now or forever hold the peace. In the meanwhile, just in case there is somebody who is posing a question, I will remind you that this presentation has been recorded and we will be posting it online to our website. We'll have a link on our website so that you can have access to this as well. So give me about a week to figure out all the technical parts and get that loaded, but it will be available for your future reference. No last questions? So, would the three of you stand there for one last time? Wait for the camera.
Are we taking a bow?
No, but
I don't think that deserves a bow.
the recording.
They don't want to clap.
I started the recording before you had an opportunity to introduce yourself. So to wave to the camera, this is John Harford and Carol Quinn and Megan Hennigan, and they have been your attorney presenters for today. So without further ado, I want to thank you all for joining us. Stay tuned as we do future ethics forums. We'll be soliciting you all for future topics that you might be interested in. You can always send an email to education@jcope.ny.gov if you have topics that you would like to see a future forum on, or if you have any questions or follow-ups for this presentation, you can send it to legal@jcope.ny.gov, where the attorneys can help you suss out any of your situations if you had questions that we didn't get addressed for today. So without further ado, I will thank you all very much for joining us, and I will end this meeting.